Girl, you think you got it bad. Girl, you think you got it bad. Girl, you think you got it bad. Got our different ways with the same old layout. Had our own dreams with the same old outcome. Had it by a string and the same old breakdown. Worked it to the bone with the same old habit. Girl, you think you got it bad. Girl, you think you got it bad. Girl, you think you got it bad. Got our different ways with the same old layout. Worked it to the bone. 'cause they don't know yet. Tasting even sweeter in the morning. God, you shouldn't come without a warning. Come save me now. Come save me now.
Term Intelligence is a groundbreaking new benchmarking solution that enables you to compare LPA terms against the wider market. Whether you're a fund manager, investor, legal advisor, or consultant, Term Intelligence can help you gain a comprehensive view of fund terms in a notoriously opaque market. Sourced from thousands of constituent funds, it offers the largest repository of aggregated and anonymized LPA data in private markets and enables you to draft more competitive fund terms, conduct thorough pre-investment due diligence, speed up LPA terms negotiations, and secure the best possible terms for you or your clients. Explore Preqin's Term Intelligence today.
Good afternoon, everyone. I'm excited to introduce this next new keynote interview with two well-known speakers. The Division of Investment Management, as you all know, is one of the most important divisions to our industry, shaping regulatory policy for investment advisors, mutual funds, and other registered funds. It's an exciting time. There's been a lot that's happened. Now with the new chair, the new administration, I think we'll see a lot more changes as well, additional product innovation and other developments. So it is my great pleasure to introduce these next two speakers. It should also be a very fun interview, from a former director to the current director. So Natasha, who I've known since we've been at the SEC, we were just talking, has been with the SEC serving 9 SEC chairs, quite a feat, I think, so a lifelong government service, providing a lot of the support that the industry needs. And our interviewer, Dalia Blass, I don't think really needs much introduction, but has been a successful partner of MFA, working on behalf of the industry, engaging in a lot of new ventures and exciting developments. So happy to introduce and welcome our two speakers.
Okay, it's you and me. So first of all, thank you for making it today. I know it was like trains, planes, and automobiles to make it, given the weather between DC and New York. So thank you for taking the time to be with us. And I know we have questions that we want to get through, but selfishly, I gotta ask. I was a lifetime IMer. You were not. I'm gonna put you on the spot. Favorite division? There's only one right answer.
So I feel like there's press in the room, so I have to be careful with my answer. But so I've been at the Commission for quite a long time, over 20 years, and I think I'm a unicorn a little bit in that I've worked for multiple divisions, OC before it was exams, trading and markets, enforcement, and now I am. Each experience was wonderful in its own right, but I'm sitting next to you only so that you don't harass me and make me have to lay down like I'm getting therapy on the sofa. I'm going to say I am, because that's my current position. But it's also because it's an interesting time. I mean, I came in kind of the tail end of the prior chair's tenure, when there was a lot of rulemaking, but there was also very robust comment files. And so I was able to really be impactful on moving certain rulemaking forward in the way that I think was practical, moving forward, especially based on my experience, where I think made decisions not to move certain rulemakings forward for various different reasons, but also got to be part of a transition with the acting chairman, Ueda, and now the new chairman, Paul Atkins. So it's very unique. I know that 9, had not count that. But I've worked for 9 chairs, and each have their own personality and their own priorities. And so to be in this position with 3 chairs has been actually very unique and actually quite fun.
So speaking of that, Natasha, the division actually has, it's the smallest of the policy divisions in the commission, but it has a huge mission, regulating investment advisors and investment funds. So with that, and sort of with the opportunity of you being the director of that division, can you talk to us about sort of priorities that you would have for IM?
So as I was saying, with acting chairman Ueda on board, and he is a IM alumni, and so were his staff at the time when he was in the acting position. We everybody's like, oh, it's, you have transition, it's going to be quiet, you're not going to get anything done. We got more done in 4 to 5 months than I ever expected. With his support, also with our advocacy as a division, that we wanted to move certain things that we weren't able to move before. One of the things about the staff, which is quite impressive, is how quickly they pivot. Even with all the other things that are happening in the world and with the agency, they are always keyed in and focused on kind of getting the job done and thinking about what can we do today that maybe we couldn't do yesterday. So we got a lot done. I'm going to actually take a couple minutes, just if you don't mind, to talk about a couple of things that we were able to move on. With the support of the acting chairman, we were able to move on ETF share class, and actually we were doing a lot of work behind the scenes, but start engaging with the applicants earlier this year. We've made a lot of progress. We have about 60 applications currently and have done a lot of active engagement, and I'm very hopeful that we'll be able to move on that sooner than later. It does go through the commission, so it's not a division or staff action, so there's still some work to be done, but I'm very hopeful and excited that we were able to move it forward. It was something I think historically that the industry had wanted. We've been getting a lot of pressure to move it and finally got some momentum, which is pretty exciting. But a lot of work that will go into it. Recently, late in April, we issued via delegated authority a new streamlined co-investment application. That was a lot of work that had gone into, I think even during your tenure, it was something that you talked about, that we got done pretty quickly, mainly from the fruits of the labor of staff over the years, some of which are still here, that kind of said, hey, we could try to move this forward. And we talked about it, and I said, let's do it, and got support to move it forward. I think not only is it good for the agency and the division, because it's a good, the streamlined application makes it easier for applicants to move forward on co-invest applications, and because there's a lot of things that are not now required in the application that took a lot of time for the staff to review, and there was a lot of back and forth. But it still has the investor protection aspects that we wanted to retain, but it kind of removed a little bit of the board obligation. They no longer need to do a transaction by transaction analysis. They also, we kind of broadened what types of affiliates could be incorporated for purposes of co-investment. And then we also had a requirement to adopt policy and procedures, which the board would review as part of their position and review. So we have a lot of applications still remaining. One has been approved, a number in the pipeline, and we're thinking about how best to move those forward. We have probably over 40 applications at this point. So I think this is a first step. It's something we wanted to get done, and I think it'll iterate over the coming months and years, but give the industry a path forward to, again, just try to create some efficiencies, because, as you can imagine, we are kind of a small but mighty division. And if you spend a lot of time on the things that we think are more routine, we don't focus on the novel issues. And so this is our effort to try to kind of move that forward. We also provide exemptive order for allowing privately held BDCs to issue multi-class shares, which this has been something we've been wanting to do for quite some time. Public traded BDCs already had this, so it didn't quite make sense why you couldn't do it for a privately traded BDC, so now both can do it, which I think, again, is really kind of a practical, thoughtful path forward for that space. As we are I come from exams, so providing guidance to promote compliance for new rules or existing rules is kind of my jam. So I brought that forward in this role. One of the things that I really wanted to tackle when I took on this role was the marketing rule. I don't know that we're going to relook or reopen a marketing rule. I'm not saying that, but I did want to provide some guidance for some pain points that I think had been out there for over now 3 years. I mean, if we can't fix it in 3 years, industry is still having problems and we're not getting the right result. I think the division has the responsibility to kind of do and be active in that space. So we issued a FAQ focused on the one, I think, or two that we thought were most important to get done. Doing a package of FAQs is much harder, but in a short period of time, if we could get these out, mainly relating to the presentation of net and gross performance. And I think I've never gotten more press by way of IM work once those were published and issued. And it was a lot of actually, it's not just the work of the staff, it's the work of the industry, because what I've been promoting is engagement. And so a lot of the work was previewed with various industry groups, particular registrants, consumer investor groups, just because we want to get it right. The problem is if you don't have the engagement, you really just have your own perspective within the building. And I think it's short-sighted. So really wanted to promote the engagement in this space. It takes a lot of work and a time, but if you can get it right in the end, I think that's the right result. So that was, I think a huge accomplishment and really just the tip of the iceberg. I think there are many other questions that the industry has posed to us as it relates to the marketing rule that we'd like to address, whether it's through speaking events or additional FAQs. So more to come in that space. We also, just with the names rule, Form PF, compliance dates upcoming, we did issue some FAQs. We also updated FAQs because they were stale at this point with amendments to those rules. Again, just providing additional clarity to the industry as the industry is kind of moving forward towards implementation. In that vein, there's been a lot of requests for compliance date extensions, and we as the commission, it does require commission action to extend a compliance date, maybe something a lot of people don't know. So it does take a little work, including a short release and a back end for us to do it. We extended Form PF compliance date, names rule, and also the NPORT. As many of you know, we're currently under litigation, the Fifth Circuit, for NPORT. So we extended the effective date and compliance date for names rule for 2 years. And we're looking at the requirements under NPORT to see if we want to do a potential reproposal in the guise of the executive order, and a lot of feedback from the industry.
Natasha, that was a lot.
I know, and I still have more, so if you want me to keep going.
No, kudos.
And I would be remiss if I also didn't mention crypto. Working really hard with the crypto task force, Commissioner Peirce, and now Chairman Atkins. On moving crypto forward in a practical way and providing clarity in that space. We have I would say as IM has a lesser component. I mean, I think CorpFin, trading and markets have some of the bigger issues, but we all work as a team. We're trying to work through the issues. Custody is a big issue for us that we're tackling, and we're hoping to provide clarity in the coming weeks and months and years. We'll probably anticipate some rulemaking in that space as well.
So, there was a theme that you touched on, which is really important, which is just because something was done does not mean that it just is rest and does not get untouched and updated. We did marketing. I will confess, not the best rule ever. Definitely has a lot of pain points. So I think it's fantastic you guys are looking at it. The co-investment, we did the Apollo order. It definitely put a lot on the board, and the transaction by transaction was not working. So kudos for taking things that just because they were done, established, moving them forward. But speaking of crypto and speaking of the fact that you came in and inherited an agenda, like none of the rules that are on the books right now that were proposed, open or done, were done by you. But there are a lot of open proposals right now from Chair Gensler's time, and they've all gotten a lot of, let's say, substantial feedback from the industry. You mentioned one, safeguarding. Your thoughts on these open proposals and what, if anything, IM is going to be doing with them?
So yes, I call it robust comment files. The SEC positive twist. But no, yes, I did come into a pretty robust rulemaking agenda. I think obviously with acting chairman Ueda, but now the new chairman, we've been having a lot of dialogue about what rules should go forward and those that should not, to be quite honest. I can't get into specifics yet, but I think the spring regulatory agenda will come out. It's a very unique way for us to kind of preview and set the tone for what we're going to look in the coming months and years under Chairman Atkins' tenure. We're also looking for other ways to provide clarity and transparency because of the concern about all the rules that we're going to, which ones will move forward. Because really, I think from an SEC standpoint, from a policy division, we're looking to have you focus on the right things. So if you think we have 10 rulemaking proposals that might move forward, you're going to focus on the ones that the big ones, and if we don't provide that clarity, you're not going to focus on the ones we think are going to actually move forward. And so our goal is to provide transparency of what is our policy agenda moving forward. And it's a two-way dialogue between the staff of any policy division and the now new chairman of what should go on the agenda. Some of items are pet projects that the division staff has wanted to move forward. Some are from the chairman as items that he wants to look into. And then I think a lot of it is also from feedback from the industry. But not everything is rulemaking. I think you make a good point on like the marketing rule. We don't always get everything right, but we should learn from it. And there are other ways that we could provide clarity, whether it's staff guidance, FAQs, maybe provide exemptive relief. And we've been looking at all those tools in the toolbox because rulemaking, especially with the new ORIRO process, is not going to be as quick as we would like. So we want to focus our efforts for rulemaking and then think about other ways that we can be impactful to provide guidance or change in the industry.
So speaking of which, we touched on the rules that are proposals that are open. There are rules that were adopted by Chair Gensler and the commission at the time that, now looking at them, looking at compliance, there are significant pain points. One of my pet peeve ones, the names rule, which has always been a problem. And just my personal opinion here, I think the changes sort of exacerbated problems that are in the rule. But, as the industry grapples with rules that are currently on the books, and not speaking about any specific one, but just ones that were adopted, is there any openness to engagement for rules that have been done but that are presenting compliance changes? What are your thoughts on that?
100%. I mean, the thing that I've been promoting since I started this job last March is come and talk to us. My big joke is that no one came last March, but they have been coming since January. I don't know what changed, but whatever. I have not changed. I'm still asking for engagement. But I do think this is perfect. This is perfect time to come and talk to us. And I will say, you would not be alone. Industry groups, particular registrants, have been meeting with us more frequently since November, since January, and it is increasing over time. A lot of the rules, some of which were recently adopted, have been extended compliance periods. This is the time to talk to us pre-implementation. But I don't think you should just think about the rules that happened or occurred in the last 3 or 4 years. There are rules on the books from a long time ago that just don't work anymore. And I think us having awareness of why and how we might be able to address those issues, I think is very important, because these are the conversations that we or I bring to the chairman or to discussions, internal discussions about what we should be focusing our efforts on. And so I can't explain or say it enough that you should come in and talk to us. We're very open. It can be virtual, even though we're in the office 5 days a week now. Whatever makes it easier, we're happy to talk it through. And we do take it back. Just like with the comment files, we look at it, we consider it, and we try to be thoughtful about how best to move it forward. And most chairmen, if not all, always ask, like, what does the industry think? What are the pain points? What are we going to focus our efforts on? And so I think it's invaluable. The one other thing I would always is we kind of move forward at some point in additional rulemaking. One of the things I think, and it's so hard because I know the rulemakings have such complicated aspects to it that you focus on different things. But one of the things we don't get a lot of comments on is compliance periods and operational pain points. Those are the discussions we always seem to have after adoption when you start thinking about implementation. And so to the extent you can engage your operational non-lawyer staff to say, okay, this is the rule that's going to potentially go in, what are the pain points so that we would know? It's helpful to provide more reasonable compliance periods so that we're not extending, because we then later learn about issues, like using vendors or having to re-paper or look at contracts with vendors. Those are things that you don't hear as much until after the fact. And so having comment letters that address those type of issues are really helpful. And I think we also need to do a better job because we don't seem to talk, at least what I've observed in a lot of proposals, we don't talk about comment periods, and we need to set the tone and ask the questions and have you also focus on it. So we'll do a better job on that as well.
I mean, I have to say, Natasha, that was one of the first things I said. I said, like, I love you all lawyers, but if you could please go and talk to your operations and compliance folks, and in your comment letters, make sure that your views are represented. I cannot, stress that point. Having done rules for a living for a long time, it's always after the fact. You think you have a great rule, the comment letters were supportive, and then compliance starts, and then all this stuff comes up. When compliance people would have, at least caught some of it if they're brought in. So completely agree with you. I think that's a really great message, and thank you for sharing it. So I can also attest that the staff of the division have been, my words, freed. They've been extremely responsive. It's been great having conversations with them again. So we're very grateful for that. But we're also aware through, recent changes that there have been a lot of changes in the staff, including significant number of retirements of longtime staffers. So can you sort of tell us, as you're looking at the change in the division, the impact of that on the division's operations? You have a very ambitious agenda, but you are down staff. So how would you how you're threading that would be interesting to hear.
So we in IM have had a lot of staff either take retirements or leave the SEC for other professional opportunities or just something new. And I think even with the significant number of staff that left within our division, we still have a deep bench of experienced, ambitious, bright attorneys, accountants, fellows, analysts that are doing a phenomenal job. I think one is a great opportunity for kind of junior or mid-career staff to get professional opportunities to kind of move up, and also just realize who else we have. I do think that we need to kind of think about, when you lose as much staff as we did in one time, if you can imagine losing one really good staffer or two really good staffer, when you get into a higher number, you have to think, or you have to retool, reprioritize, and kind of pivot in a way. But in all of that, I've never noticed that we're lacking experience or passion for what we do. There hasn't been anything that we wanted to do that we couldn't do today. So I think that's positive news. But I do think it's in some degree, and since I have an audience, is just be patient with the staff, because many staff are now doing the job of one or two people, and until we can kind of see where the gaps are and maybe potentially hire to fill those gaps of personnel numbers, but also experience. At some point, hopefully in the future, we are still limited in how many people we have in the division. But we're also being creative. Like, we know we want to get something done. We're talking to the industry, we're talking to outside counsel, and we're thinking about ways that maybe we can provide relief more globally versus applicant. So we're thinking about ways to be impactful without using as much resources, so being efficient. And so I think that's what we will continue to do on a daily basis as we kind of move forward. But it is hard to lose wonderful staff that have been there for years and years. You do lose kind of like historical perspective that's hard to just pull out when someone's like, oh, 20 years ago this happened. Someone who just started there 5 years ago will not know. But we are still a very, I know Jen, when she introduced, IM is one of the premier divisions within the agency. And just because we lost some staff doesn't change that.
So looking around the room, Natasha, there are folks that have spent time in the commission, but there are also folks that have not, and sometimes that's a bit of a the unknown. Can you just kind of walk people through the Division of Investment Management, just the components of the the division?
Sure. Is this like a test? I feel like.
Yeah. Can you remember now?
So IM, one of the unique things about IM, I've worked in many divisions in the agency, is we have a rulemaking team that specifically writes rules. They have a 40 Act side and an advisor side. They now, with kind of retooling, when you think about retooling, we are kind of cross subsidizing projects based on expertise, but also those that are still remaining in the rulemaking division. But they have foundationally know how to write rules. We don't talk about how to write a PRA or a Reg Flex. You talk about substantively how do you move a rulemaking from a policy perspective. It is something that's very unique to the agency, and I have to say probably the golden standard of rulemaking, despite what rules come out of it over the years. But they are they're a critical part of the division, but not the only. It's what everyone seems to talk about. We also have the Chief Counsel's Office. We actually just recently named, or I recently named, a new Chief Counsel, Holly Hunter-Cece, who has rejoined the division. She's maybe in her 3rd week now. And that office does a lot of the exemptive applications, guidance pieces. They do phone day. They do international work. A lot of division work as it relates to providing guidance post-adoption. And one thing I learned over time when I took on this job is the rulemaking team writes the rules, but after about 6 months post-adoption, there's a transition to the Chief Counsel's Office. So you normally will still see someone from the rulemaking staff either being consulted or be in the room, but ultimately that Chief Counsel's Office is supposed to be the resource, because if you still maintain all the questions coming out of rulemaking, they can't do rulemaking. So we kind of share the experience and the expertise that gets built within the Chief Counsel's Office. Then we have our disclosure review and accounting office, 2 parts. One, they look at fund filings for purposes of registration statements, and those then go effective. And we also do fund accounting reviews. Under Sarbanes-Oxley, we have a 3-year requirement to look at all funds accounting. And so they have a very robust accounting group that looks at all funds accounting. So a lot of engagement on both the disclosure review side and the accounting group. That we have a managing executive office like every other division, but uniquely we also have an analytics office. They're kind of like the quiet powerhouse within our division. They do a ton of work. They're looking at all the data that you're submitting through filings. We're compiling it. We not only compile it for our own analysis, but we've, in the last year, done a really concerted effort to publicize that data. So actually in the last year, we have 3 new public reports: the Investor Advisor Report, there's an Investment Company Report, an Ensign Report, and then we've enhanced more recently the Money Market Fund Report, and then last year we enhanced the Foreign PF Report. So a lot of data that we're now pushing out to the industry or registrants so that they also can utilize the information. And I will be honest, not just the industry, it's also for domestic regulators, international regulators who want to get us kind of a peek into what our industry looks like. So I think I hit all the high points.
You did.
I'm like, what did I miss?
you didn't miss any office in the division, so I got kudos for that one. And I'm not going to tell you which one is my favorite, but I do have a favorite office. Speaking of which, one of the other pieces that folks sort of externally may not be aware of is how the division interacts with the division of exams and the division of enforcement. So can you speak to that piece?
Yeah, of course. So even before I got there, there's always coordination between the policy divisions and exams and enforcement. But in particular, because I have that experience, I kind of wanted to take it up a notch. And when I was it probably started when I was in exams. I thought it was really important from an examination perspective that the Investor Advisor Investment Company Examination Group, which is about 60% of the examination division, coordinate and learn from the policy division, whether it's a review of risk alerts, talking about potential exam findings for the marketing rule. It was a huge lift for examinations division to start examining for compliance with the marketing rule. And at the time, IM was not providing any guidance in that space. So I knew that all the letters from the marketing rule initiative were going to be very closely looked at by outside counsel, the industry. And so what we did is we kind of worked hand in hand with IM and had a review group. So every deficiency letter for the first year after the compliance date for the marketing rule was looked at by an entire team to ensure consistency. So if you got a letter from Denver or Miami or New York, they should have been consistent in nature. So that kind of, I brought that experience over, and I wanted to continue that with exams. And we still do that. We don't look at every deficiency letter. It's almost impossible. We don't have the resources for that. But we do try to partner with them and provide guidance and ensure. Our goal as a policy division is to make sure that the rules that we or the commission adopts are being applied appropriately, even outside of our division and through the examination function. But it's a big task, so it's a lot of work. We also work with enforcement. So every recommendation that has an IM touch, we review and we participate in the closed commission meetings if there's questions by the commissioners or the chairman. And so a lot of involvement. But a lot of those investigations kind of move through the investigator process and then come to us. But then sometimes, I think they see novel or new issues on investigations and they will bring us in much earlier. So we definitely like to advocate that. We're a little bit more short-staffed these days, so we're trying our best, but we're still trying to advocate a lot of positive engagement. I think it's very important, especially on the enforcement side. Every case that you look at has a policy implication. If they don't get it right, I think it's very impactful to our division and the agency.
Natasha, thank you. Thank you first of all, for being here with us today, but thank you for your decades of public service. And we're very, very grateful, and for all the initiatives that you're launching, because they're really important for the industry. And I know that we all look forward to working with you and the staff to move us forward and get more out of you.
Thank you.
Hopefully, but just if you'd all join me to thank Natasha for her time. Thank you.
Okay. Are we live? Can people hear me? Hi, good afternoon. I'm David Forum. I'm an investment funds partner at Sidley Austin here in New York, and I'm delighted to be moderating our panel on international regulatory and legal developments. It goes without saying that we live in a very volatile international environment, and that volatility intersects with what seems to be like an ever-changing regulatory environment, and that intersection has